Surviving a charge sheet. How to avoid common mistakes in your reply. Getting hit with formal disciplinary action is honestly terrifying, but today we're going to build a logical, totally stress-free strategy to protect you and your career.
Listen closely to this. If you reply to a charge sheet emotionally, you are weakening your case. Look, it is completely normal to feel angry, maybe betrayed, or just terrified when you first read those allegations. But letting those raw feelings dictate your written response, that is literally the fastest way to undermine your own defense. We've got to pull back to pure logic here.
You see, panic leads to avoidable mistakes. When a charge-sheeted officer, or CSO, gets these official documents, the immediate reaction is almost always pure panic. You feel like your whole livelihood is suddenly on the line, right? And that panic triggers a very real biological fight or flight response. The problem is, this physical reaction actively stops your brain from writing with the clear, concise logic that inquiry officers desperately need to see. You basically stop thinking like an objective professional analyzing data, and you start defending yourself like you're in a heated personal argument, and that leads directly to critical, completely avoidable errors.
So let's look at the real problem here: presentation over facts.
When we really look at the reality of most disciplinary cases, the core facts actually aren't the issue. The objective evidence, things like system logs, closed accounts, or prior audit clearances, is usually solid. It's verifiable. The fatal flaw almost always pops up in the presentation. Because a CSO is operating under immense stress, they often end up writing this messy, highly emotional defensive novel. And when an inquiry officer is handed a chaotic, rambling document, those pristine, objective facts just get completely lost in all that noise.
That brings us to the 4 common mistakes. Basically, what absolutely not to do.
There are a few specific pitfalls that routinely ruin a perfectly good defense, and we really need to pinpoint them so you can avoid them like the plague. First up, writing emotionally instead of logically. This means relying on loaded words like unfair, targeted, or betrayed. Second, mixing all of your points together into one massive, unreadable paragraph. Third is writing these long, unnecessary explanations that go way beyond the actual scope of this specific charge. And the fourth mistake, not addressing each allegation separately. Now, why are these so damaging? Well, a long, rambling explanation literally forces the disciplinary authority to go digging for the truth. And human nature being what it is, if you make their job difficult, they're probably just going to skim your document and completely miss your strongest evidence.
So, what does this all mean? If we know exactly what not to do, how do we fix this? How do we take a complex, highly stressful situation and methodically turn it into a clear, impenetrable defense? Well, take a deep breath, because this is entirely fixable, and the answer is actually incredibly straightforward.
Let's dive into the simple solution: winning with structure.
This right here is your blueprint for a perfectly organized reply that leaves absolutely zero room for misinterpretation. Step 1. Keep your replies strictly point-wise. If there are 5 charges, there have to be 5 separate replies, no exceptions. Step 2. Keep it clear and short. Just strip away all that complex legal jargon. Step 3. Stick to the facts and only the facts. Mention the date, the document number, or the specific operating guideline, and leave it at that. And finally, step 4, maintain a calm, respectful tone. Honestly, this is perhaps the absolutely crucial mental shift you can make. You're no longer a victim crying foul, you're a competent professional carefully responding to an administrative process. This strict adherence to the facts is, hands down, the best way to protect yourself.
A simple tabular format is basically your secret weapon here. By placing the specific allegation directly next to your hard evidence, and then following it with a crisp, one-sentence reply, you're creating a bulletproof defense. The inquiry officer is literally forced to confront your facts directly. They just can't skim over a structured point-by-point table the same way they would a 5-page letter. Structuring your defense methodically like this perfectly mirrors the best practices for making sure your side of the story is seen, understood, and totally respected.
Let's leave off with this absolute game changer of a thought. Most cases don't fail because of facts. They fail because of poor presentation. You already have the facts. Now you have the structure to present them. So right before you submit your final response, take a step back and ask yourself, is your current draft an actual defense of the facts or just an expression of your frustration? Strip away the emotion, stick strictly to the structure, and protect your career. You've got this.